Something subtle is already off in this courtroom. Before any motions are heard, before jurisdiction is argued, there's a quiet mismatch between procedure and perception. The judge is operating inside structure. The defendant believes structure itself is the problem. And when those two worldviews collide, the case stops being about charges and becomes about control.
Case People versus Dwight Miller.
Ashley Lonnie for the people.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Miller, who approaches your. Mr. Miller, can you please state your name for the record?
Dwight Miller.
Thank you.
And Your Honor, my belief is that my client does want to set this for preliminary examination. However, I am uncertain. He and I have had some conversations, and frankly, I believe he wants to make some statements to the court. I advise him against it, but at this point, I think he wants to talk.
So we're understanding this is a criminal matter, right?
It is.
Okay, so basically, man, it stemmed from a falsality. All this whole thing, I was falsely arrested, something I never did. I got a sworn affidavit.
Sir, I'm sure your counsel has advised you. I'm going to advise you to not say anything else about the subject matter of the case.
Okay.
If you'd like it set for preliminary examination.
I want to challenge jurisdiction.
You want to challenge jurisdiction?
Yes.
Of whom?
Y'all have a jurisdiction of a case that doesn't exist against you.
On what grounds?
What crime did I commit?
Pardon?
What crime did I commit?
Allege that you committed the crime.
I didn't commit that crime.
Resisting. If you want to interrupt me, I'll answer your question. But if you want to keep interrupting me, I'm not going to play that way. I'll answer your question. You're accused of the crime of attempted resist, or not attempted, but resisting and obstructing a police officer.
So we all aware that this never transpired, right?
I am not aware of that.
This is a familiar sovereign citizen strategy, but notice the judge's restraint here. Rather than escalate, the court redirects, keeping the record clean while limiting self-inflicted damage. It's a procedural chess move. Allow the defendant to speak just enough to move the case forward, but not enough to derail it.
Okay.
Is that all you have to say?
Mm-hmm. Yes, sir.
So, Your Honor, I would ask Mr. Miller. Mr. Miller, I'm not submitting frivolous motions.
Can I get my affidavit put in on the record, please?
Affidavit.
My affidavit of the incident that transpired.
Your affidavit of what?
The facts in the case. My statement of what happened. Can I get it on the record?
There will be an opportunity if you so choose, if this goes to a further proceeding, for you to put whatever evidence you want into the court. But this is not the time to do that.
Really? So when is the time to put the evidence in there?
If you want it set for a preliminary examination, you'll have that opportunity. And if it proceeds to trial, you'll also have that opportunity.
Right.
So once again, I'll ask, do you want to set this for preliminary examination, Mr. Miller?
Sure.
Thank you.
Not really.
See, do you want to set it for prelim or do you want an adjournment?
Preliminary examination.
Thank you.
To your knowledge, all discoveries.
To my knowledge, yes, Your Honor.
People have their witnesses available the 24th.
Yes.
We could try for that date, Your Honor, if possible. I might ask to go one. No, let's do that date. Thank you.
All right. Preliminary examination in person will be set June 24th, 2025, 9 a.m. That is before Judge Washington.
Thank you, Your Honor.
Thank you.
You want to get this camera? They will have it. I will make it.
Court does call the case People versus Dwight Miller.
Ashley Feltus for the people.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Miller, Your Honor.
He's still muted.
I believe he is orange pants, white shirt, Judge.
I got it.
Oh, I was just happy I could read it.
Thank you for pointing that out. I figured out where he was. Oh, there he is. Mr. Miller, can you state your name, please?
He may be muted, Judge.
No, he's not muted.
Oh.
Sir, can you state your name?
On and for the record, my name is Dwight Miller. I'm American State National. I'm here to challenge jurisdiction. I'm here on special appearance this time with jurisdiction, bro.
Can we approach, Your Honor?
Your Honor, I need to challenge jurisdiction.
Okay, how are you intending on doing that?
Well, Your Honor, can you show me your how I'm supposed to do this? See, it's certain things I can't remember because y'all got me in here and I don't have access to the law books. But it's okay.
There are certain things you want me to show
your
you?
delegation of power, sir?
Pardon?
Can you show me your delegation of power and your oath of office?
What's happening now isn't confusion, it's exhaustion. The court has already answered the legal question, but the defendant keeps reframing it emotionally. That gap matters. Judges listen for law, not narrative, and repeating a rejected premise rarely creates leverage.
Delegation of power.
Yeah,
Came from the people of Washtenaw County that elected me. I have a certification of election in back. You want it?
Mr. Miller, as your
I would like
attorney,
a copy of your surety bond, please, and your oath of office.
My surety bond. I don't
Yes.
have one. I'm insured by the county.
So you don't have one?
And state.
Okay. You don't have a surety bond, huh? So what's your oath?
Mr. Miller, I'd advise not to
swear oath to the Constitution, right? Yes or no?
I'd advise you not to continue this line.
Man, I'm in here. I done got victimized this morning. Are you serious? Can I get a breakout room with my attorney or my so-called attorney?
So-called attorney? No, he's a very good attorney, and he's not a so-called attorney, and you'll not refer to him that way because as you won't be disrespected, neither will he.
Okay, may I speak with the attorney in a breakout
You
room?
can do that on your own time. He doesn't get a breakout room here because he's live in the courtroom.
Okay. So
what are we doing with his case now that my jurisdiction has been established?
okay, I'm putting the motion in for dismissal because ain't no so-called witness or victim to sign a sworn affidavit against me.
Please approach, Your Honor.
And not end this? Yeah. Oh. Of course, yes, you may approach.
So how's y'all having a conversation without me being there?
Okay, we're back to the record in the Dwight Miller case. What I'm going to do, Counsel, you're requesting an adjournment in this matter.
I am, Your Honor. Upon information, believe there may be a new case coming. I understand Mr. Miller booked into the jail at 10 o'clock this morning.
Your Honor,
so I want to evaluate.
I object anything she talking about. First and foremost, how was you testifying?
That what?
First and foremost, Your Honor, I want this charge dismissed, man. At no time given, the lady lied.
I know, I heard your motion to dismiss.
Okay,
I denied
listen.
it already.
Listen, Your Honor, under the Constitution, what is it exactly? The maximums of law. If something comes from a falsehood, what is that? The first words out this woman's mouth, she lied. She made a story up talking about somebody
Okay,
put a
this
weapon
woman
at her.
is
Nobody
an
pulled no
assistant
weapon at her because
prosecutor.
nobody
first
had
of
no
all.
weapon.
I believe he's speaking of the complaining witness, but
Oh, the complaining witness. Oh,
But you-
not Ms.
but
Hudson?
Mr. Miller, I would advise you not to say anything more. Given the circumstances, it may be prudent to discuss this matter further and to see there's a couple other things pending as well as a potential new charge they're indicating. This might be something we want to set over for a week.
No. I'm not worried about no new lies. Look at me. I got beat up this morning, bro. I called Pittsfield police 13 times.
This is the turning point. When multiple issues surface at once, new allegations, overlapping cases, the court's priority shifts from resolution to containment. Adjournment here isn't avoidance, it's damage control.
I was getting assaulted with motherfucking tasers and shit.
Okay.
I put it on the record. Then all of a sudden they want to switch it up to make it seem like I'm threatening somebody. I ain't threatening no one.
Okay, but we can't resolve
I
all
never
that today.
threatened no one. The same people
I
that's
know.
making these statements, they all three on
So-
felony probation. They done got caught.
Okay.
Their house
Okay,
just got
so we
raided.
can't resolve
And then they up
that
here
today.
playing line up on me.
Okay, so look, we can't resolve that today. And I think the best thing to, so that everybody can try to figure out what's going on, is I'm going to adjourn it out a week. Rather than 2 weeks. I'll try to expedite it. Let's see if we can get to the bottom of it all. So,
Your
probable
Honor,
cause conference.
Your Honor,
Probable cause conference will be adjourned to November 6th, 2025, 9 a.m. Bond will continue.
And I should correct my statement, Your Honor, that mag thing we saw, we discussed at the event, I think it's just the court it's going to. I don't know that it's revolving the court. Okay.
Thank you.
so I just got railroaded, huh?
No, that's not railroaded.
Yeah,
I'll let you know when that
because I'm
goes.
not consenting to none of this.
Can you?
The lady, the
Yeah, cut him. I'm done. I'm so done. Is he gone? I feel a cold coming on for the 6th. It's like a hairball. I don't know.
In the end, the court chooses pause over confrontation. No dramatic ruling, no emotional payoff, just a procedural reset that preserves the record and keeps the case moving forward. Moments like this remind us that courtroom power isn't loud, it's methodical. If you found this breakdown insightful, hit like, comment your thoughts, and subscribe for more real courtroom analysis.